of course is what we'll seek to do. So Cinderella is what we're left with, and I hope the analogy is not too forced. In the past, certainly, judicial review could claim to have been a Cinderella subject amongst banking litigators, a sort of poor relation, rarely encountered, usually kept below stairs. But in the last 18 months or so, it has bucked that trend, and most obviously in the case of the judicial review relating to the London Metal Exchange, which has seen hedge funds challenging the cancellation of $12 billion of nickel trades and seeking close to $500 million in damages as a result of their cancellation. But also in wider developments, in particular, the Court of Appeal has twice had occasion to address the jurisdiction of the Financial Ombudsman Service in the last 18 months, and there have been 3 other High Court decisions in relation to the FOS also. So at least in that sense, perhaps somewhat fanciful sense, Cinderella has gone to the ball in the last 18 months, and given the regulatory momentum towards the banking space, she looks set to stay there. Moving aside from metaphors in terms of the structure of this talk, I intend to divide it into 3 parts. I will start with some general comments about the nature of judicial review in the financial services space. Secondly, I will look at some of the developments within the Financial Ombudsman Service cases themselves, the ones to which I've referred. And then the third part, which is going to be by far the most interesting and charismatically presented, will be done by Michael about the London Metal Exchange judicial review itself. And since that case is under appeal, and I'm acting for the LME in it, I'm not going to comment upon it, but Michael will have plenty to say. So I'll start with some sort of noddy heads-up points as to the structure of judicial review in this field. So who is reviewable? Well, very obviously, all of the main players, all of the acronyms, if I can put it that way, the public bodies that operate in this field are susceptible to judicial review. But also, there's the private bodies who are exercising governmental functions. So I give examples there of the LME itself, most obviously. The question being not so much whether an entity is institutionally public, but whether or not, on a functional basis, it is exercising governmental functions. What is the body doing? And if what it is doing is essentially governmental in nature, then it is potentially susceptible to judicial review. What is judicially reviewable? Well, that will all be very familiar, I'm sure, to everyone. But the canvas is broad. A claim for judicial review can relate not merely to particular decisions, but also enactments, the promulgation of guidance in a regulated space, and also a failure to act. And I have sought to catalogue what might be the 4 main categories of judicial review: regime changes, market interventions, decisions affecting particular firms, and decisions not to act. Plainly, some of those are more frequently contested, item 3 being the one that most frequently troubles the courts. This slide can probably be passed over quite briefly as being something reminiscent of an undergraduate primer in terms of the main heads of judicial review. I'm sure they'll be familiar to everyone. But really, the question is, well, what is it that is distinctive about financial services judicial review? And I've picked out 3 characteristics which are by no means unique to financial services or indeed universal to all of the cases in that space, but I think they capture some common themes. So the first is we have expert decision makers in a specialist field. Now, a feature of judicial review generally is the court's reluctance to intervene, the latitude that it affords to primary decision makers. And that is magnified in this particular context simply because of the specialist nature of the subject matter in question. Now, if that first feature of financial services judicial review may discourage intervention, the second frequently makes it a more realistic prospect. And that is that financial services is congested by hard-edged legal concepts to which there are right or wrong answers. So the FCA handbook, as an example, is a sort of jungle of statutory instruments or collation of statutory instruments, which often bring together or define the regulatory perimeter. And if the court considers that a regulator has gone astray in its interpretation of that perimeter or of those hard-edged concepts, then the court will be more willing to intervene. And I've given 2 examples of cases which I've done myself recently, where one has had these threshold concepts of what is a transferable security in the Donegan case, and what does one mean by access to a payment system in the context of note machine. The third characteristic which I draw out is that affected parties are likely to have valuable possessions under A1P1, by which I mean Article 1 of the first protocol of the European Convention of Human Rights. So this is a point that Michael may bring out more in the context of the LME case. But the Human Rights Act, strictly speaking, is a misnomer because it confers rights on persons, not on human beings, which means that corporations, both great and small, enjoy its protections. So I think the person on the Clapham omnibus might spill their latte if you inform them that a hedge fund had human rights, but they do. And some of those rights include a freedom from unlawful interference with possessions, which in this context means or includes financial contracts. And that is significant in this field of judicial review because if regulatory action impairs or extinguishes contractual rights, and if that regulatory action is shown to be unlawful, then that may provide the basis for a damages claim under the Human Rights Act, which cuts through even if the regulator has a statutory immunity, as most of them do, because the immunity does not extend to exempting oneself from liability for human rights damages. So establishing those sort of common features, I'll now come and look at some of the recent law in relation to the FOS, and dwelling in particular on the first of the two features that I identified, and as I say, the third may be one that Michael picks up when he comes onto the LME. So the FOS, I'm sure many of you will be familiar with the fantastic FOS, and it's a quasi-judicial body, as I say in the slide. It makes awards up to $430,000 to eligible complainants, which is principally to consumers. And the ethos of the whole enterprise is efficiency, speed, informality, or at least that's the idea. Cases are decided not by reference to the law, but by reference to what the FOS considers to be fair and reasonable in all the circumstances of the case. Having said that, the FOS does have to have regard to relevant law and regulation. So the law is a mandatory relevant factor, but it's not dispositive of fairness. And that creates a tension in judicially reviewing the FOS between the court, on the one hand, as the arbiter of the law, and the FOS, on the other, as a quasi-judicial adjudicator, which is to be afforded a very wide latitude in making pragmatic decisions as to what fairness requires in any given case. And that tension reflects, in many respects, the history of the FOS, which was set up beginning of the noughties as an entity that was going to provide pretty rough and ready justice for consumers with relatively low monetary thresholds. I think what's happened over time is the monetary threshold has crept up, so we're now talking $450,000 in each case, but also the reality of the sale of financial products to consumers is that one is generally talking about mass market products. And so decisions which are made on issues of principle potentially read across to the entire industry. And one can therefore see decisions which are being made on this fair and reasonable basis, but which have potentially multi-billion or hundreds of millions of pounds of consequences for multiple different financial services firms. So there have been, in the last 18 months or so, 5 significant cases, 2 in the Court of Appeal, 3 in the High Court. They are all pretty dense and cover matters such as asset-backed timeshare packages and retail credit agency arrangements. If I were to embark on an excursion into the facts and reasoning in each of these cases, then the long-awaited drinks would be inexcusably delayed. So you'll be relieved to know I'm not going to do that. What I've tried to do instead is to distill into a series of propositions what I think one can glean from these recent cases as they move the law relating to the FOS progressively further forward. So the first proposition, the FOS is a creature of statute and its jurisdiction is limited by law. So in words set out by the Court of Appeal in Assurant, it cannot act without jurisdiction simply because its error was reasonable. Now that all sounds perfectly intuitive. You can't pull yourself up by your bootstraps. And what that means is if there is a threshold question, the court has to decide, does that question set the limits of the FOS's jurisdiction, or does it relate to the exercise of that jurisdiction by FOS? And the answer to those 2 alternatives will determine the scope or the intensity of the review that the court will bring to bear. And that gives rise to some fairly fine distinctions. And I give 2 examples at the bottom of the slide. The first one of my cases where there was an issue as to whether or not someone was an eligible complainant. Were they a consumer for the purposes of the challenge that they were seeking to bring? And the court determined that was ultimately a question for the courts because it set the parameters, set the jurisdiction of FOS. Conversely, in another case, the limitation period of 6 months, specifically whether it had expired, was found not to be jurisdictional. So although that did, in a sense, set the parameters of the FOS's jurisdiction, that was nonetheless a question which FOS was competent to assess for itself on the facts, rather than that assessment being second-guessed by the courts, save in cases of Wednesbury unreasonableness. Second, the duty to take account of the law means that the FOS must not misdirect itself as to what the law requires. And I've then sort of inserted the question, well, what does that actually mean in practice? Because when is something, properly speaking, a matter of law reserved to the courts? Now, some points of law are obvious. I mean, if one makes an abstract statement of what the law requires, or a proposition, a general proposition. Equally, if one is interpreting a document, most obviously a contract, those are points of hard law which will then be addressed by the courts and reaching their own view and second-guessing the FOS as much as they please. However, more difficult is when one is looking at the application of the law to the facts. Now, strictly speaking, on a purist's view, at bottom, that is an issue of law. I mean, once the facts are established, if one is talking about how one then characterizes the legal significance of the facts, one might say, well, that is essentially a question of law. But the view that has been taken and affirmed recently in the appellate decisions has been that hard-edged definitional questions will be treated as matters of law, which will be reserved to the court. And I've cited some examples from the cases there in terms of whether a timeshare agreement, for example, or whether an agreement is a timeshare agreement, or whether it's a collective investment scheme, just as one example, or whether or not key information has been or has not been provided. However, if the question is more fact-specific and evaluative, so one is applying the law to facts which are more open-textured, or which require a greater degree of assessment by the Ombudsman, then that may be treated by the court as something which is subject only to Wednesbury review. And I give there the example of whether or not a firm's marketing had breached the prohibition against the sales of timeshares as investment. I think in practice what we are seeing is that the courts are trying to tread a line, sometimes a rather murky one, between preventing legal error at the level of principle, but not intruding and second-guessing upon more case-specific questions which bear on judgment and degree, because in reality to do so would undermine the feasibility of the FOS regime as being something which can, in the majority of cases, proceed uninterrupted without being called into question by the courts. The final proposition which I draw from the cases is that if FOS intends to depart from the law, then it must explain its departure. So FOS is not required to follow the law, but in the event that it chooses to depart from it, it must explain why it has done so. Now, the classic statement of that was Heather Moore and Edgecombe in 2008, and it was pretty clear if the Ombudsman is going to depart, they have to say so in their decision, so acknowledge that they are departing, and then explain the reasons for that departure. I think what's interesting in the last year or so is that in the cases one has seen something of a dilution of that expectation. So it is said that I've got a statement from the options case as to what is not required. So one is not required to set out all of the relevant contractual provisions, tortious duties, etc., and then state why in a particular case one is going beyond that. So you don't need a sort of exhaustive cataloguing process of analysing the relevant legal framework. What is required, and I think this formulation I find more troubling, and this is in the Charles Street case, is that they must indicate that they've considered the common law principles, but then concluded that what is fair and reasonable is otherwise for reasons which they identify. Well, what I would say just in closing in relation to that is the law is a relevant consideration within the FOS regime, and the ability to challenge for legal error is only meaningful if one can identify whether an error has in fact been made. So the reasons given by the FOS must be sufficient to permit that. And at a minimum, I think that means the FOS must identify what it understands the relevant law to be, the fact that it does not intend to decide the case in accordance with that law, and the reasons why. Because those three things are needed in order for the courts then to properly exercise their supervisory responsibilities in the event that a judicial review is brought. Thank you for your patience. That's the sort of, as it were, synopsis of developments in relation to FOS. I'll hand over to Michael in relation to the LME.
well aware I'm now the last man standing between you all and a drink. So, depending on your perspective, I suppose that makes me either the headline act or the graveyard shift. But either way, I detect the thirst in the room, so I'll be brief. But as Jamie says, I'm going to talk about the Administrative Court's judgment in the Elliott and Jane Street and London Metal Exchange case. Now, Jamie's already introduced it, but the LME case is one of the most significant financial services JRs of recent years, and I know it'll be familiar to a lot of people in the room. But I think it's worth spending a couple of minutes on the key points at issue in the case, what the court decided, and what we can take away from the litigation so far. So in a nutshell, the LME case is about the power of a regulated investment exchange to cancel trades in circumstances of market disorder. The claimants were Elliott Associates and Jane Street. Elliott Associates, hedge fund, and Jane Street, a trading firm. And the defendant were the London Metal Exchange itself and its clearinghouse, LME Clear. The LME is the world's main trading centre for industrial metals. Now, both the LME and the LME Clear are profit-seeking enterprises, but they undertake regulatory functions under FSMA and a framework of domestic and retained EU law. So their regulatory decision-making is amenable to judicial review. Now, the claimant said the LME's decision to cancel certain trades in March 2022 was unlawful. And on top of that, they sought substantial damages of around $460 million in lost profits. Indeed, as everyone who was involved was well aware, that was what was really driving the litigation. So it's a JR, but you have a commercial party on one side, a commercial party on the other side, and a substantial wedge of cash potentially on the line. So don't worry, banking litigators. I know this is a session about JR, but there's not a public interest NGO in sight. However, the claimant's damages claim was based on breaches of their human rights. As Jamie has already said, hedge funds have human rights too. And in this case, the claimant said that the cancellation of trades had interfered with their right to property, protected under Article 1, Protocol 1 of the Convention, or A1P1 in the jargon of human rights law. So what exactly were the claimants complaining about? Well, their beef was with the lawfulness of the LME's response to significant price rises on the 3-month futures market for nickel in March 2022. On the 7th of March 2022, the price of nickel futures rose by 70%. That was more than 5 times the size of the biggest daily price move in the preceding 20 years. But there was a reason for this. Russia, a major nickel producer, had just invaded Ukraine, and everyone expected a squeeze in supply. But in the early hours of the 8th of March, there was an even bigger spike. Prices soared by a further 100% in around 5 hours. And this movement couldn't be explained by the situation in Ukraine. So the LME decided that the market had become disorderly. And the LME was concerned that market participants with short positions could not fulfill their margin calls. In other words, they couldn't cough up the amount of collateral that they needed to pay to the LME Clear in order to keep trading. And the billions of dollars required could push some of them into default. So, the LME suspended trading in nickel, and it decided to wind back the clock to the market close on the previous day. So that is, it cancelled all trades placed on the morning of 8th of March. So in their judicial review claim, Elliott and Jane Street said this cancellation decision was unlawful. They made 3 points. First, they said the LME did not have the power to cancel their 8th of March trades. They said the cancellation power in the LME rulebook is limited. It has to be done according to a published procedure, and it's only available for things like trading errors. Second, they said that even if the LME could cancel the trades, its decision was procedurally unfair. The LME should have consulted affected participants, like Elliott and Jane Street, before it cancelled the trades, but it didn't do that. And third, the claimants argued that the LME's decision was irrational. They said it took account of improper considerations, including the risk of market participant default. They said it failed to take into account relevant considerations, including the cause of the price surge, which the LME did not even investigate. And they said that the LME had irrationally rejected possible alternatives to trade cancellation. And on top of that, as I've said, the claimant said the cancellations interfered with their A1P1 rights. So faced with that claim, the admin court decided to split the trial. It would address the lawfulness of the trade cancellation liability under A1P1 first, with quantum deferred to a second trial. However, the second trial didn't come about, because the court dismissed Elliott and Jane Street's case on liability. On the claimant's first ultra vires argument, the court concluded that the LME did have the power to cancel trades under the LME rules. The power under Trading Rule 22 was broad, where the LME considers it appropriate. It could cancel, vary, or correct any agreed trade or contract. Now, that was only exercisable in exceptional circumstances, but that included the situation on the 8th of March. And the exercise of that power wasn't subject to a trade cancellation policy already being in place. On the procedural fairness argument, the court concluded that the LME did not need to consult the claimants before cancelling their trades. It wasn't required to under the legislative framework or the rules, and it was for the LME to decide who, whether, and how to consult. And it was entitled to a wide margin of discretion in that regard, particularly in an urgent situation. And the court also rejected the claimant's submissions on irrationality. It was appropriate for the LME to take into account the risk of default, which could have seriously undermined market confidence. Further, the LME could rationally conclude that the market was disorderly. Futures prices were disconnected from the price of the physical commodity, and there was no geopolitical explanation for the price surge. So the law did not require further investigation, and nor would it have made any difference if the LME had looked into it. And it was not irrational for the LME to reject the alternatives to cancellation. The LME and LME Clear could rationally conclude that those alternatives could leave LME Clear dangerously under-collateralized, and in any event, such an alternative might not have prevented market participant defaults. Finally, the court turned to the A1P1 claims. Now here, the claimants weren't in exactly the same situation. When the decision to cancel the trades was taken, Jane Street's trades were complete. It had a set of completed contracts. But Elliott didn't. Elliott didn't participate directly on the exchange. It placed trades through LME members via a chain of back-to-back contracts on terms reflecting the LME rules. It had a contingent agreement to trade with the ultimate counterparty, but the chain of contracts was incomplete when the market was suspended. And critically, Elliott had not concluded an actual contract for the sale of nickel, and it didn't have any right to sue for the sale price. This, the court decided, meant that Elliott's A1P1 claim simply didn't get off the ground. Its inchoate commercial arrangements were not a possession within the meaning of A1P1. And the court accepted that an extant contractual right was a possession, and it accepted that a concept of a possession could extend to a legitimate expectation of a proprietary right. But what Elliott had wasn't enough. It didn't have a contractual right to sue a counterparty for the purchase price, so there was no chosen action and there was no property. And there was no frustration of a legitimate expectation of property, because that could only arise in respect of property that was already in existence. And the contract between Elliott and the LME member trading on his behalf didn't yet exist. So that put paid to Elliott's A1P1 claim. As for Jane Street, as I said, it didn't have the same problem. The court accepted that it had concluded trading contracts, and those were possessions within the meaning of A1P1. But the court refused Jane Street's A1P1 claim nonetheless. It held there was no interference with the property, because trades were always subject to LME's cancellation power under the LME rules. Jane Street had chosen to trade on the LME rather than, for example, through the OTC market. And in making that choice, Jane Street had consented to being bound by the LME rules, including those concerning cancellation. And that consent was conditional on the power being exercised lawfully, in public law terms, but the court had already concluded that that had been done. So, in a nutshell, therefore, Jane Street hadn't been deprived of anything. The loss of the contracts was a result of a bargain that Jane Street itself had made. So the claim failed. The LME didn't act unlawfully. There'd been no interference with the claimant's A1P1 rights. And for Elliott and Jane Street, there were no damages. Indeed, no quantum trial. So, to go back to Jamie's rather tortured metaphor, Cinderella did not get to go to the ball, let alone meet Prince Charming. I recognise in this somewhat tortured analogy, and I've cast those acting for LME, including Mr. McClelland over here, in the role of the ugly stepsisters, and just for the avoidance of doubt, to protect my own career prospects, I consider you both beautiful inside and out, Jamie. But in any event, the LME decision is on appeal, and judgment is due in the near future. And whilst that's pending, I think there are 4 points we can take away from the litigation and from the Admin Court's judgment. First, it's a reminder that investment exchanges like the LME can be amenable to judicial review. So it's not just the FOS and the FCA and the like. Second, it shows a return of human rights claims based on A1P1 in the financial services sector. It's not the first time it's been tried, and those in the room may remember the Bank Malat litigation. But this shows they're back on the agenda. Third, this litigation shows the difficulty of claims of this sort. The court will show significant deference to an investment exchange as a specialist decision maker, particularly in cases of market emergencies. And it sees sophisticated parties trading on such exchanges as having consented to and accepted the rules of the road. Fourth, and finally, the court's approach to petitions has significant ramifications for the viability of A1P1 cases concerning commercial contracts. The court drew a line between a contractual right that exists, which can be a possession, and one that is only anticipated, which can't. And that's obviously particularly pertinent in financial services, where commercial arrangements are complex, transactions often regularly involve multiple parties, and often back-to-back contracts. So that's it. Any final words, Jamie?
No, not on that. I'm very grateful because I'm mindful of the passage of time. So thank you for bearing with us. And obviously we're happy to take questions, but it may be best to do those over a drink. I don't know if Paul's already preempted my thoughts in that regard. So yes, I think that's it's all over. Thank you very much.